Welcome to Honest HR. I'm your host, Monique Akanbi. Did you know that the American with Disabilities Act, also known as the ADA, was signed into law on July 26, 1990? And while it has transformed the workplace, many HR teams are still faced with real questions about how to apply it, especially as ADA continues to be adjusted over the years. Today, we're focusing on HR guidance around ADA and is as it relates to before, during, and after the employee life cycle. So, in other words, during the recruiting and hiring process, while employees are actively working in their roles, and then leading up to and after an employee's departure from their organization. We're going to focus our insights and advice mostly on legal compliance. In other words, what the law requires all employers do for individuals with disabilities. But along the way, we'll answer some top ADA questions SHRM gets through our HR Knowledge Center from our members. For our conversation today, we're joined by two experts, Amy Epstein Gluck, a partner at the Pierson Ferdinand law firm and chair of the Employment, Labor, and Benefits team, and SHRM's own Alan Smith, who covers employment law news and trends on our content team. Welcome to Honest HR, Amy and Alan.
Thank you.
Thanks.
So, Amy, just to set the stage, if we could, I love to start our conversation more on, no pun intended, human level. For a lot of people, the ADA is a legal framework, but for you, it's also personal. Can you tell us about your connection to working with the ADA and why it means so deeply to you?
Sure. Thank you for that question, Monique. It's not one that I'm asked often. Um, I'm a management side lawyer and I help employers comply with the ADA and state anti discrimination laws. I've always been focused in that capacity with destigmatizing the idea of mental health disabilities so that employers can comply with their legal obligations. But this became quite personal to me with the birth of my third child, my son, Sam. Sam was born with no vision at all. And while his vision resolved, he remains extremely myopic, one of those employees who has an invisible disability that nobody would know about unless he told them. I have another child who struggles with mental health disabilities. And I've talked to her over the years and worked with her over the years about asking for the reasonable accommodations she needs, both at school, of course, and in the workplace. So, yes, it is quite personal to me on both a personal and professional level.
Thank you for sharing that, Amy. Alan, I believe that you have experience as well. Would you like to share kind of your personal connection to ADA?
Sure. While it's true that I have a mobility impairment, I think it's also fair to say that for the most part, it's irrelevant for work purposes that I have a mobility impairment. I do require occasional accommodations, things like occasional time off for medical appointments, or just something as simple as a chair at get togethers. But I think it's the rare employee that doesn't need an accommodation of some kind, particularly when there are so many people with disabilities.
Yeah. Thank you for sharing that. Um, for both you, Alan, and Amy, can you share your thoughts? Amy, you can go first on why ADA remains such a pivotal piece of legislation for workplaces today.
Of course, of course. The ADA is a cornerstone of workplace equality and inclusion. At its core, the ADA ensures that individuals with disabilities have equal access to employment opportunities, which benefits those individuals and enriches our workplaces with different perspectives and talents. The law sets clear standards for reasonable accommodations, prohibits discrimination, and requires employers to engage in an interactive process. For HR teams, since you asked, understanding the ADA is not just a matter of legal compliance, it's also a strategic imperative. The law continues to evolve through new regulations and court decisions, so staying current is essential to avoid expensive litigation as well as reputational damage. More importantly, and believe me, as an employer side lawyer, I see this all the time. HR professionals are often the first point of contact for an employee who is seeking a reasonable accommodation or experiencing barriers to equal access in the workplace. So HR's knowledge of legal requirements is really pivotal to minimize risk.
Alan, any thoughts on that?
Well, I couldn't agree more with all that Amy said, and I'd just like to add that the ADA, like any law, is evolving as times change. What it's meant to be a reasonable accommodation changes. First, there was, the internet, and that affected things like career job sites. And now there's AI, and that affects things like how many different types of new accommodations are available that maybe weren't available before, even as it also creates new barriers. So I think it's important to keep up to date on the law as it evolves.
Thanks for sharing that. So I mentioned that we're going to cover ADA and during the entire employee life cycle. So I like to get started at the beginning, which is the recruiting and hiring phase. And as a reminder, SHRM members have access to a plethora of ADA resources for the entire employment life cycle, including how-to guides, toolkits, customizable policies, checklists, forms, and more. I will say when I practice HR, going to the SHRM website and utilizing those resources, whether it was for ADA or anything else that was relevant to my role, SHRM was definitely my go-to. Amy, what do HR teams need to do when it comes to ensuring ADA compliance during the recruiting and hiring phase?
Well, first, HR must ensure that all job postings and application materials are accessible to applicants with disabilities, which includes providing alternative formats or accessible online platforms. During interviews and assessments, HR really needs to be prepared to offer reasonable accommodations like sign language interpreters or extended time for written tests or in the case of my son, who we were talking about, maybe larger font in a written application if it's requested. It's also important for HR to train hiring managers. If you take away nothing else, that is really my mantra. Train your middle manager, train hiring managers to avoid questions that could elicit information about an applicant's disability and to focus instead on the applicant's ability to perform the essential functions of the job. Throughout the process, HR should maintain clear communication with applicants about their rights and the availability of accommodations.
So I have a follow-up question for you, Amy. You mentioned when those requests are made. So during the recruiting process, so if I'm an applicant who has a disability, how do I go about letting the HR team, or how does the HR team create a process so that way applicants can share the needs during just even the application process? Is there something that HR teams can do?
I mean, I like when I see a job posting, if it doesn't have a little disclaimer at the bottom, I think it should be added that if the application, there needs to be an accommodation to access the application or to fill it out, then the employee just needs to touch base with HR or the hiring manager and they will help them out.
Thank you. Alan, what are some common oversight or missteps that HR teams um, tend to make during this process, during the recruiting and hiring process?
Yeah, I would just add that with the use of AI in the screening process these days, AI, if it's not used with HI, that is human intelligence, can screen out people based on irrelevant factors when it comes to being able to perform the essential job functions, like someone may stutter or someone may not be making eye contact much, and AI may screen the person out because of these physical characteristics that have nothing to do with the person's ability to do the job with or without reasonable accommodation. So I think that's a big one.
I'm glad you brought that up, Alan, because my next question for Amy is actually around the components of ADA, where they talk about essential job functions and marginal job functions. Amy, could you share kind of the difference between the two, and why that distinction matters for HR teams under ADA?
Absolutely. And I want to stress, Monique, all these questions are great and they're common questions that I get every day in practice. So, the difference between essential and marginal job functions are the fundamental, are the actual duties of a position. Essential job functions are fundamental to the position. Like you can't do the position without those duties. They're critical to the job's purpose and they cannot be removed without fundamentally changing the role. On the other hand, marginal job functions are duties that are not central to the job and they can be reassigned to another employee or even eliminated without significantly impacting the position. You asked, why is this important for HR teams under the ADA? Well, it's a distinction with a difference, and it's important for HR teams to know because employers must provide reasonable accommodations to enable people with disabilities to perform essential job functions, but not necessarily marginal ones. Clearly identifying which duties are essential helps ensure fair hiring practices and protects the organization in the event of a legal challenge. It also guides HR in making appropriate accommodation decisions and in drafting accurate job descriptions.
Okay, so I've gone through the application process. I am now hired, Alan. This question is for you, which is a common question that we receive from our Knowledge Center, which is, what exactly is the process for handling an incoming employee's request for ADA accommodation?
Well, the short answer is the interactive process for um, discussing an accommodation, which basically is just fancy language for a conversation. And one important step, too, is recognizing that an accommodation request has been made because a person doesn't have to use the words reasonable accommodation. And sometimes even an accommodation request maybe should be obvious and the person may not even have to say that, but usually they have to kind of indicate help in some form or other. But um, back and forth discussion between the employee and the employer, and it's not a one and done thing. You may try one accommodation and it may not work out, or you might try one accommodation and it may work out for a while, but then start to not work at a certain point in time. Maybe the person's condition has changed, at which point you just don't stop. You re-engage, and it's not an endless process either, but it is an ongoing process.
Can I add to that for a minute, Monique?
Sure, absolutely.
So, what I like to say is it's not a one and done. And another very typical question I get about this, about what Alan said in terms of it being an ongoing process, is well, when can we stop? Right? When is enough enough? And what I will tell you, my HR people, since you are my people, is don't be the cause of the breakdown of of the interactive process. There's no bright line. There's no timeline on it.
Well, those are certainly words of wisdom. And Alan, you said something that really stood out to me, which is um, trying out different accommodations. I think oftentimes, as people managers or HR professionals, we sometimes get caught into thinking of one way of providing an accommodation. And if that doesn't work, maybe abandon, the process in terms of trying to identify another way. So I love that you mentioned, multiple ways of identifying or trying out accommodations to the benefit of the employee or the individual with the disability. So I'm ready to go into the next phase of the employee life cycle, which is during employment. Now, Amy, our SHRM knowledge advisors have noticed a significant increase in employees requesting remote work as ADA accommodation, particularly in the area of mental health conditions and chronic illnesses. So, how should HR navigate these kinds of requests?
That's a great question, Monique. And I have been writing about this for the Pierson Ferdinand employment blog since 2020, right? It is, there's such an uptick in requests for remote work as an ADA accommodation since really the pandemic, when everybody was working from home. Not only that, we've seen just a meteoric rise in the disclosure of mental health conditions. That's not a bad thing. In fact, I would say that's a good thing that people are disclosing mental health conditions and saying to their manager, hey, I need time off to go to therapy, right? So, but to your question, when an employee requests remote work as an ADA accommodation, HR really needs to approach each request on a case by case basis, engaging in an interactive process with the employee to understand their specific needs and limitations. It's an individualized assessment. It's not a cookie cutter type of process where you've provided one accommodation for one person, another employee is going to get the same. It is important to assess whether remote work would enable the employee to perform the essential functions of the job without causing undue hardship to the organization. So, when considering a request for remote work and engaging in the interactive process, HR should consider that as well as the job description to see what the essential functions are, past practices, and consult with managers to see if remote work is a reasonable and effective accommodation. Clear documentation of that process and decisions is essential. I cannot stress enough how important it is to maintain documentation of the steps that you took to ensure the employee could be successful. Now, when I mentioned consulting with managers to determine if remote work is reasonable and effective, when somebody is working from home, managers still have to manage. And what we saw during the pandemic was that people, for a large part, were as effective working from home as they were in the office or in the workplace to the extent that they could work from home. So it may require some tweaking with management styles and tools to manage people working from home.
So, question for follow up, actually, Amy, for you is that can an employer deny a work from home request as an ADA accommodation?
So if in-person attendance is an essential function of the job, then yes, they can. Right. So for that, what are we talking about? Security guards, waiters, cashiers, a driver. A driver is not going to be able to work from home. So HR doesn't have to remove, the employer doesn't have to remove essential job functions, but it may need to reassign marginal ones, like we talked about before. So, what you need to see during the interactive process is if the employee's job can be done effectively from home. Now, understand that an employer can suggest an alternative to working from home, and several factors should be considered in determining the feasibility of whether an employee can work from home. And if any duties require use of certain equipment or tools that can't be replicated at home. Other critical considerations include whether there's a need for client-facing interaction, any face-to-face interaction in person with customers or any colleagues at time, or if an employee needs to have immediate access to documents or other information located only in the workplace or that can't be transmitted electronically, although it's hard to imagine what those could be. An employer should not deny a request to work from home as a reasonable accommodation only because a job involves some contact and coordination with other employees. Because often meetings can be done effectively by phone or Zoom or Teams, and information exchanged quickly through email. Like my firm, which is fully remote, most things can be done in an office setting on a remote basis. So that's part one of my answer. Part two is that if the employer determines that some job duties must be performed in the workplace, then the employer and employee may want to talk about, some kind of hybrid situation where the person's working part-time at home and part-time in the workplace, and if that will meet both of their needs, right? Like, for example, an employee may need to meet with clients as part of a job, but if there are other tasks, just reviewing documents and writing reports, they can do that at home.
Alan, what should HR teams do if an accommodation plan has been put in place for an employee, but another employee refuses to follow it? So I'll give you an example just to kind of follow up, right? So let's say you have an employee who's on ADA leave as a part of their accommodation, and their workload needs to be redistributed to other team members on a temporary basis. And you ask the coworker to do some of that work, but they're pushing back and saying that their plate is already full. What should HR or even people managers do in that scenario?
I think this can be a challenging one because there are at least two issues involved that I see, and one of them is the confidentiality requirements of the ADA and being sure that in discussions with this colleague, you're not violating the confidentiality provisions of the ADA. And then there also, secondly, might be performance issues with that colleague. Are they fulfilling other duties as assigned if that's something in their job description? And I guess another consideration is if this person says, well, I can't do this, it's too much, it's gone on too long, um, whether there are options, can some of that work be shared with other employees? Um, and yes, there's the consideration of, is this being a disruption so that it's an undue hardship? But frankly, that only comes up typically at smaller employers because most large employers can absorb the work. So it's a tricky question.
Amy, if an employee discloses a disability and requests an accommodation after receiving a disciplinary feedback, but the employer doubts the legitimacy of their disability, what steps should HR take?
HR should tread carefully as to this issue for confidentiality reasons as well as guidance from the EOC. According to the EOC, an employer does not have to rescind discipline, including a termination or an evaluation warranted by poor performance, just because an employee has disclosed a disability or requested an accommodation after, receiving a written warning or an oral warning or whatever the case may be. If the employer doubts the legitimacy of the disability, it should request documentation to support the request for accommodation if the disability is not visible. Having a disability is not a shield against discipline for poor performance. So timing is critical here.
Okay, so let's go into the next phase of the employment life cycle, which is post employment. So, Alan, my question is for you. And I believe I saw this on the HR Daily newsletter that I received from SHRM, which is the Supreme Court recently dismissed a retired firefighter's ADA bias claim, emphasizing that the limits of ADA protections for individuals no longer actively employed. How can HR ensure compliance with ADA requirements while also addressing potential bias claims from former employees, particularly in cases involving post employment benefits um, or retirement accommodations?
Yes, I think that this is an interesting question because the decision itself was quite fragmented. Um, the individual plaintiff in this case, their claim involving retirement health benefits, that was blocked. Um, and the majority in the first two parts of the opinion seemed to be indicating maybe all retirees' claims would be blocked in such a circumstance. And yet, in the third part of it, um, and if you also take into consideration the dissent, there seemed to be an indication that from a plurality of the court that there might be some circumstances where someone who is retired, if they can show that they're a qualified individual with a disability, could bring a claim, which almost makes me wonder if it was a matter of pleading. But I do think that it does place new limits of some kind, but this may be one of those decisions that's generous to lawyers because I think there's some issues here that might be litigated on down the line.
All right, Amy, what are your takeaways from this recent decision?
I'm nodding my head
I
because
know, I see.
this is such a lawyer's decision. So, two words, right? From a compliance standpoint, timing matters. It may seem obvious, but if you are completely retired, you're no longer protected by the ADA. You're not in the workforce, you're not seeking to be in the workforce. The ADA doesn't protect people who don't work anymore, right? Um, but as Alan was alluding to, it seems from the decision that there are ways to plead around this issue. Like what I can see plaintiffs doing is saying that, well, the plan changed while I was employed and I was disabled at that time and I suffered the harm at that time that the plan changed and I was still an employee. So, but even though I'm retired now, I was an employee then. Now, that's all well and good, but they would still need to file a timely charge of discrimination, right? They would be able to plead, but they may not know about the impact before the statute of limitations runs on their time to file with the EEOC or the state agency.
Thank you for sharing your takeaways on that. So, Alan, another question directly from our Knowledge Center, which is, can an employer terminate an employee who can't perform the essential job functions, even with accommodations?
Well, this is another challenging one, as is so often the case with ADA questions, because while in theory the answer is yes, you also have to stop and think, wait, might there be leave as, a reasonable accommodation if this person is unable to perform the essential job functions right now, but on down the line, if leave were granted for a definite period, they could perform the essential job functions and after ADA leave has taken place, or as a last resort accommodation, could this person be reassigned to a vacant job position?
So, Amy, you mentioned timing matters. So, my next question actually is for you. Was an employee with a disability departs an organization? Is there anything the employer needs to do to support the individual as far as continuing benefits or providing certain documentation for their next employer?
Well, it's almost a follow-up to Ellen's question, which is documentation matters, not just timing, right? Employers must provide information about continuation of benefits under COBRA if the employer has a group plan. And other than that, it really depends on the state. Some states require written notices upon termination and some don't, but that's all that I'm aware of.
Thanks. So, as we get ready to wrap up, I have one question for both of you, but Alan, I'm going to kick it to you first. Based on the work that you've done with covering ADA, what's one thing you wish every HR professional understood about it?
Well, I do think that most HR professionals are aware of this, but some people still aren't aware of the fact that in most jurisdictions, there is such a thing as ADA leave. So when FMLA expires, you have to provide ADA leave for a definite period, the one exception being the Seventh Circuit, Illinois, Indiana, and Wisconsin for extended leave. So just don't forget ADA leave.
And then Amy, a little twist to the same question, but because you mentioned earlier that it is very important that HR train and educate people managers as well as a part of this process. Not to say that they need to know all the ins and outs of ADA, but as a people manager, as a supervisor or a team leader, middle management, they need to at least have some level of knowledge around ADA and whether it's the interactive process or accommodation. So, what's one thing you wish HR teams or HR leaders would do in support of people managers outside of just education, um, so that way they understand the importance of ADA?
Education is the most pivotal aspect here. I guess I would say a couple of things. One is that compliance is not being nice to an employee with a disability. It's a legal obligation, right? I hear sometimes managers say, we're like the best employer because we provide an accommodation and we're still struggling with this and we don't want to do the interactive process anymore. But it's a legal obligation. You're not just being kind and lovely. And the second thing is, you know, really training middle managers and hiring managers and HR to understand when somebody is asking for an accommodation. Because, as Alan aptly said, no magic words are needed. You don't have to say, hello, I would like a reasonable accommodation under the ADA. Would you start the interactive process with me? They don't have to say that. Sometimes employees don't even know that they have rights, as to their disabilities in the workplace. So, really listening to employees when they're asking about needing time and for what reason, I think is pivotal, and understanding the different laws like the ADA, the FMLA, and workers' comp and how they would apply to the different situations. I would say that this is one of the most common questions I get is around providing accommodations or around people requesting time off for physical therapy or doctor's appointments and things like that. So it's that knowledge piece.
Can I add one thing here? I think it's important too to remember state laws. I mentioned the Seventh Circuit, but while the Seventh Circuit held that, you'd need to check Illinois laws and Indiana laws and Wisconsin laws and local laws to really cover your bases.
Yeah. Yeah, that's true. And to Alan's point, in some states have a lower standard for knowledge, right? It's knew or should have known that somebody needed an accommodation. So knowledge of state laws is critical.
And shameless plug, as a member of SHRM, you have access to a multi-state law comparison tool, which is something that I absolutely love because then you can select ADA and the states if you have employees in multiple states, and it provides that side-by-side comparison. So thank you for sharing that. And that's going to do it for this week's episode of Honest HR. A big thank you to Amy and Alan for sharing their deep insights with us. Honest HR is a part of SHRM's HR Daily flagship content series. You can head over to shrm.org/HR Daily to learn more and sign up for our newsletter. You can also catch us on SHRM's social media. Be sure to like, comment, and be a part of the conversation. Thanks for joining, and until next time, stay well.
SHRM.
This podcast is approved for 0.5 professional development credits, aka PDCs, toward SHRM CP and SHRM SEP recertification. Enter the following PDC activity ID in your SHRM activity portal to log your credit: 26-SA65H. That's 26-SA65H. This ID expires on August 1st, 2026.